we've got a couple of questions here. Two, this question did drop in during your segment, but it's open to anybody if they want to chime in as well. But how does the argument about individualized negotiation and pricing work with the indirect purchaser class?
Thanks, Andy. I think I'll take a first stab at that. So I think from a farmer perspective, it's generally harder to oppose the direct purchaser class than the indirect purchaser class, right? I think that's at least in part because of the additional complications that are down the supply chain. So the instances where, you know, you have a court to certify the DPP class, but they won't certify the indirect purchaser class, and thus in the same case. I think earlier I listed Lostrin and Intuitive. You have other cases like Wellvillian as well. So in the reverse payment settlement context, you can have complications down the supply chain, like the presence of brand loyalists or consumers with flat co-pays, or you can have the end payers who negotiate special deals with the PBMs, for example, so that, you know, they receive different amounts of rebates, they pay different prices. So I think that would apply to the individualized negotiation as well. Generally, that'd probably be easier to do at the indirect purchaser level than the direct purchaser level.
Thank you so much, Josh. This question did drop in during your segment, but again, it's open to all of our panelists as well. But do individual negotiations necessarily require individualized evidence and methods for establishing common economic impact?
Yeah, so I would kind of echo what Thu said, that it certainly makes it harder, and that's only kind of exaggerate, or even more so the further you go down the supply chain. But I would say not necessarily, and I would say that because, you know, the relevant comparison is how a given plaintiff's economic position in the actual world compares to what that same plaintiff's position would have been in the but-for world. So if there are various market forces or structural features that kind of limit the extent to which suppliers are able to price discriminate against buyers, or that it's the case that the purchasers who had a certain amount of bargaining power in the but-for world, or sorry, in the actual world, unless that conduct, you know, changed their bargaining power, a given purchaser could have still had bargaining power in the but-for world, and so you could still see some price variation between plaintiff or between purchasers, and yet there could be some structure to the market that kind of the rising tide lifts all boats argument. But I think in those instances when there are individualized negotiations, the focus has to be on, can you demonstrate that there is such a structure, or there are those market forces that would kind of keep some amount of cohesion to the price variation, rather than getting trapped and trying to focus on just the individual negotiations. I think the focus needs to be on, is there a structure that would keep them together? And if so, did the conduct affect that structure in some way?
Thank you so much, Josh. Another quick question here for you. If averages are not sufficient for demonstrating class-wide injury, is there still a role for regression analysis when evaluating common impacts?
Potentially, certainly. And I would say, first of all, averages is kind of an ambiguous term. So you could have an average, but that implies some denominator. And so if you are using averages to measure some attribute for the entire class, maybe you can break that into an average of two different groups. So maybe you can segment the class, and then you have two different averages. So one thing is, you could think about what you're calculating the average over. And then the other part of that is, you know, regression is really such a broad range of methods that you know, you're essentially trying to study the relationship between two or more variables. And so, you know, even if averages are at issue, there are different ways that you might be able to kind of make the regression analysis a little more sophisticated. So for instance, you could specify a model that tests the conduct at the individual or subgroup level. And this is close to what I was saying about, you know, really when you're adding variables in on the right-hand side of a regression model, you're creating different groups. And so you could use interaction terms to kind of create smaller groups. A second part is, instead of just looking at the mean with the regression, you could do, for instance, there's something called quantile regression where you look at the entire distribution. So you could, for instance, instead of saying, did the average price change with the conduct versus when the conduct wasn't happening, you could use maybe quantile regression to look at, did the entire distribution, or maybe did the 10th percentile, the 50th percentile, and the 75th percentile all change, go up or down. So, you know, because regression is such a wide range of methods, there are alternatives. They obviously have their own limitations and data requirements, but I don't think, you know, just because averages are risky at times in class cert, it doesn't mean that there's only one way to calculate them. So I think regression can certainly use to calculate more sophisticated averages that can point to the kind of ad issue question.
Thank you so much, David. A quick question here for yourself. Now, given the difficulties you've identified, what do you think are the three most important things a lawyer should perhaps think about when pursuing an antitrust case, or even before pursuing an antitrust case?
Lawyers should conduct research and investigation, learn about the market in detail before they file their case, potentially obtain data from third-party sources, and interview and possibly hire experts before they file the case. That would be number one. That's pre-filing. Also, anticipate the legal arguments that may be made regarding your liability theory and your damages theory to make sure that you have sufficient court precedents to support the positions you're going to take, because they may knock down your damage and they may knock down one of your liability theories. And third, develop a discovery plan, prepare to present it to the court, be proactive about discovery as much as possible.